My name is Natalie, and I am 31 years old. I was sitting in the quiet car of an Amtrak train somewhere between Philadelphia and Washington when I helped an elderly woman pick up a folder she'd knocked off her tray table. She introduced herself as a retired schoolteacher named Ruth. My husband smirked when he saw her walk into the mediation room beside me the next morning. His lawyer actually chuckled. 18 minutes later, that same lawyer was gripping the edge of the conference table with both hands to keep himself standing, and my husband was staring at the woman he had just mocked, understanding for the first time exactly who she was. Before I go any further, drop a comment and let me know where you're watching from, and if you've ever had someone treat you like you were nothing, only to watch it blow up completely in their face, hit that like button and subscribe. Because that is precisely what this story is about. The train had left Penn Station at 6:42 in the morning. I was heading to DC for a mandatory mediation session, the final step before my divorce from my husband Carson became official. We'd been separated for 11 weeks, ever since he had handed me a thick manila envelope one Sunday morning and told me very calmly that he'd outgrown us. 7 years. I had given that man 7 years. I pressed my forehead against the cold window and watched the New Jersey industrial corridor blur past. I was running on 3 hours of sleep and my second cup of terrible Amtrak coffee. My laptop was open on the tray table, but I couldn't focus. My mind kept cycling back to the number on the settlement paper Carson's attorney had emailed over the night before. $50,000. I want you to understand what that number meant. 7 years ago, when Carson came to me with a concept for a tech startup and no capital and no connections, I was already 2 years into my career as an intellectual property attorney at a firm in Midtown Manhattan. I spent those 7 years explaining to my husband, at dinner, on weekends, on vacations we were supposed to be enjoying, exactly how patents worked, how to structure IP filings, how to protect an innovation and turn it into a licensable asset. I thought I was being a supportive wife. I thought I was building something with him. Last month, Carson's startup closed a $14 million Series B funding round, company valuation $47 million. He filed for divorce the following Tuesday. My phone buzzed on the tray table, text from Carson. I read it once, then read it again to make sure I was understanding correctly. Sign the $50 K at mediation tomorrow or Warren will depose every client you've ever had. I'll make sure your bar license goes with you when you leave. You built nothing, Natalie. I built everything. Don't test me. I sat very still. The forensic part of my brain, the part that has spent 6 years identifying stolen intellectual property for a living, filed the message away with the same cold efficiency I use at work. Then I opened the spreadsheet I'd been building in secret for the past 6 weeks. I'd started it after noticing something I couldn't explain. Carson's company had filed 6 patents over the previous 14 months. The filings were public record. Anyone with a USPTO database account could pull them. I had a USPTO database account. What I found when I set those 6 patents next to my own case files made my hands go still on the keyboard. The technical architecture in 4 of Carson's patents matched, not in broad strokes but in the specific, non-obvious details that only exist when someone has had access to privileged work product. The innovations I had helped my clients develop and protect over my career. Carson had access to my home office during the 3 years I worked remotely. He had access to my case notes, my technical summaries, the strategy documents I'd drafted for clients who trusted me completely. He had taken that information, made cosmetic adjustments, and filed it under his own name as sole inventor. One of those patents was now generating $2.3 million a year in licensing revenue. He had used what I taught him to steal from the people I was sworn to protect, and then he had handed me divorce papers before I could figure it out. My coffee had gone cold. I was so deep in the spreadsheet that I almost missed the commotion to my right. The woman sitting across the aisle had knocked a thick folder off her tray table. Papers fanned out across the floor of the quiet car, dense, heavily annotated documents covered in tiny handwriting and colored tabs. She was reaching for them, but her hands were shaking badly and her face had gone an odd gray color. The passenger ahead of her glanced back once and looked away. No one moved. I closed my laptop and got up. "Let me help you with that," I said, crouching down. The woman, she looked to be in her early 70s, silver-haired, with the kind of straight posture that tells you someone has spent their life in rooms where posture mattered. Tried to wave me off, but her hands were trembling too much. I recognized the signs immediately. "Can we get some orange juice or something with sugar?" I said to the attendant passing through. "She needs it quickly." They brought crackers and juice. I sat with her while she slowly came back to herself, keeping my voice calm, guiding the cup to her lips. After a few minutes, the gray left her face and her breathing steadied. She looked at me with sharp, clear eyes. "Thank you," she said. Her voice was measured and precise. "I managed my lunch poorly today." "Easy to do on a travel day," I said. "Rest for a minute." While she rested, I gathered her papers from the floor. Old habit, my eyes scanned documents the way other people, faces, looking for patterns, for inconsistencies, for the thing that doesn't belong. I wasn't trying to read her papers, but when you've spent 6 years doing what I do, you can't turn it off. In the middle of a long contract document, buried in a liability indemnification clause, I found a gap. A specific consequential gap in the assignment language that would, in a dispute, leave the signing party entirely exposed. I set the papers on her tray table and hesitated. "I don't mean to overstep," I said, tapping one page carefully. "But whoever drafted this contract left a significant gap in the IP assignment clause. In a licensing dispute, the assigning party would have no protection. Depending on the asset's value, the exposure could be substantial." The woman looked at the page. Then she looked at me. Something shifted behind her eyes, a sharpening, a focused attention that hadn't been there a moment before. She put on her reading glasses and studied the section I'd indicated. A long moment passed. "I have had 4 attorneys review this document," she said quietly. "You found that in 30 seconds. "It's what I do for a living," I said. "I'm an IP attorney. Contracts are easier for me to read than most other things." She extended her hand. "Ruth Harrington. I spent many years in a classroom before I retired, visiting former colleagues in D.C. "Natalie Crane," I said. "Nice to meet you, Ruth." We rode the rest of the way into Union Station talking. She asked careful, intelligent questions about intellectual property law, the kind that come from someone who already understands the structural logic of a legal argument and is probing for how the details fit together. I found myself laying out the shape of what I'd found: a spouse who had used a partner's professional expertise and privileged client information to file fraudulent patents and pocket millions in licensing revenue. Ruth listened without interrupting. When I finished, she was quiet for a moment. "The patents are public record?" she asked. "All 6 of them filed and published through USPTO. "And the original client work?" "My own case files. I have full access as the originating attorney, and one patent contains a specific technical detail, a non-obvious algorithm variant, that I personally developed in consultation with a client. It doesn't appear anywhere in public record prior to my husband's filing date. He had to have gotten it directly from me." Ruth nodded slowly. "Document everything, chain of custody on every source. Public records separate from client files. The distinction matters." Then my phone vibrated. A photo message from a number I didn't recognize. A woman's collarbone, young, manicured, wearing a delicate gold locket on a thin chain. My grandmother's locket. The one that had gone missing from my apartment 3 weeks before. The one Carson had looked me in the eye and sworn he knew nothing about. The caption read, "She's been wearing it all week. Thought you'd want to know. See you at mediation." My grandmother had pressed that locket into my palm the last time I saw her, 3 days before she died. She told me it had gotten her through every hard thing life had ever thrown at her, that it was proof of what the women in our family were made of. The tears I'd been holding back all morning didn't come. What came instead was something colder and more useful. I put my phone face down and opened my laptop. I had 14 hours. The woman waiting at Union Station was wearing my grandmother's locket openly, like a prize. She was in her early 20s, blonde, dressed in clothes I recognized, because I had a good eye for labels and a solid memory for receipts I hadn't signed. She moved toward me the moment she spotted me, making sure her voice would carry. "You must be Natalie." She shoved a manila envelope against my chest. "Carson wanted to make sure you got your paperwork the second you landed. He also said that $50,000 is more than generous for someone who basically spent 7 years being his personal assistant." She tilted her chin deliberately. He thought this looked better on someone who actually has a future. I looked at the locket, I looked at her, I kept my voice completely even. That belonged to my grandmother, I said. I filed a theft report with the NYPD 10 days ago. The case number is already on file. I'd think very carefully about where you're wearing stolen property and whether you want to explain that to a detective. She went the color of copy paper. Before she could speak, a calm voice behind me said, "There's a car at the south entrance when you're ready, Natalie." Ruth Harrington stood a few feet back, entirely unbothered by the scene she'd just witnessed. We walked out together through the sliding doors, leaving the envelope on the floor where it had fallen. The hotel put my joint credit card through and got a hard decline. Carson had frozen it before I'd even cleared the arrivals hall. I handed the front desk my firm's corporate card. Using it for a personal hotel stay was a risk I was not authorized to take. I took it anyway because survival requires calculated decisions, and destroying Carson's certainty that he had already won was now the only thing I was working toward. In my room, I connected my laptop and worked through the night. The USPTO records were entirely public, no special authorization, no legal exposure of any kind. I pulled certified copies of all 6 patents, the application histories, the inventor certifications, and the assignment records. I built a comparison chart. Carson's filing dates against my client consultation records. I documented the chain of custody for every single source and noted clearly where each document had come from. The most important exhibit was 12 pages long. It showed a specific technical method, an optimization approach I had developed myself while preparing documentation for a client's provisional application. I had timestamped email drafts, a handwritten notation on a legal pad I'd photographed months earlier for unrelated reasons, and a client correspondence file predating Carson's filing by 11 months. That method appeared essentially verbatim in his 3rd patent, the one generating the most licensing revenue. That was not marital asset fraud. That was federal patent fraud, a crime committed against the United States Patent and Trademark Office. At 2 in the morning, a voicemail from Carson. "You think you're going to walk in there tomorrow with your little folder of printouts and embarrass me? Warren is going to shred everything before you open your mouth. Those were my business files. You accessed them without authorization. Fruit of the poisonous tree, Natalie. Your whole case disappears. And then I'm calling your managing partner. And you'll spend the next 5 years fighting to keep your license. Take the $50,000. Walk away. This is your last." I listened to it twice, then I typed 4 words and hit send. I track stolen patents. Ruth was already at the cafe table when I arrived at 6:55, 2 coffees in front of her, wearing a charcoal blazer and the particular stillness of someone who has spent decades in rooms where every word matters. I told her everything. Warren's strategy, the bar threat, the privacy argument. She listened without interrupting. When I finished, she picked up her coffee. "Warren is operating entirely within state family court logic," she said. "He's arguing your husband had a reasonable expectation of privacy in a home office workspace, standard fruit of the poisonous tree." "And he might be right about the client files," I said. My stomach was tight. "He's not right about the patent records," Ruth said. "Those are public federal government filings. There is no privacy claim possible against a public database. Any motion to suppress them will be frivolous on its face." She set her cup down, "But here is what matters most." She placed a folded sheet of paper on the table in front of me. "One of those patents contains your own original work that predates his filing by 11 months. You may have standing as a valid prior inventor. That converts this matter from a marital asset dispute into federal patent fraud, a crime against the USPTO." She tapped the paper. "Patent fraud is a federal crime. Warren's entire motion is built on state court procedure. Let him make his privacy argument on the record. Let him finish completely, then cite this." She paused and saved the video. I looked up. "Your husband was at a Tesla dealership this morning," she said, with the calm of someone reading a weather report. "He was quite candid about his reasons, and his liquid assets, and how recently available that cash had become." A friend had already sent me the clip. Carson standing in a showroom, arm around the woman from the train station, explaining to a live audience that he'd shed the dead weight that had been holding him back and that this car was his freedom purchase. His financial affidavit, filed with the mediator 2 days earlier, claimed minimal liquid holdings. I saved the video to 3 separate places. The mediation room was on the 14th floor. Long mahogany table, floor-to-ceiling windows, the expensive neutrality that rooms like this are designed to project. Carson was already seated when I walked in, wearing a suit I had picked out for him at Nordstrom 3 years earlier. He didn't look at me. His attorney Warren sat beside him. Polished, unhurried, the kind of lawyer who has confused winning by intimidation with being genuinely good at his job for so long he stopped being able to distinguish between the two. He slid the settlement agreement across the table the moment I sat down. "Let's make this simple," Warren said. $50,000. You sign today, you walk away, everybody moves on. "I won't be signing that." Carson laughed. The specific laugh he used to make me feel small. "You don't have a choice. Warren already filed the motion. Everything you think you have is inadmissible." Warren leaned forward. "My client maintained a private commercial workspace within the marital home. The files you accessed are business records protected under his reasonable expectation of privacy. Your audit constitutes an illegal search. Under the fruit of the poisonous tree doctrine, I'll have it suppressed before you present page 1. And given the sensitive nature of the client information involved, I'll be placing a call to your firm's managing partner and to the State Bar of New York." He straightened his cufflinks. "Take the check, Natalie." The mediator looked at me with the resigned expression of someone who already knows how this ends. I said I'd like to yield to my advisor. Warren's eyebrows went up. "You listed yourself as unrepresented." "My advisor is present as a consultant," I said. "She'd like to address the motion." From the row of seats behind the partition, Ruth Harrington rose. She moved without hurrying. The quiet tap of her cane on the floor was measured, deliberate. She pushed open the partition gate and walked to the table, setting her briefcase down with the authority of someone who has owned every room she has ever entered. The mediator looked up from his notepad. His pen stopped moving. I watched his face go through 3 distinct expressions in the span of about 2 seconds. Recognition, followed by something close to alarm, followed by the careful blankness of a professional person composing themselves under pressure. "Judge Harrington," he said. The words came out smaller than he'd intended. "Ruth Harrington, retired United States District Court Judge, Eastern District of Virginia. Author of the landmark ruling in Kellerman v. Synaptic Technologies, the federal case that established the modern framework for patent fraud in marital asset disputes. Author of 2 widely used legal textbooks. Current member of the Federal Judicial Conference Ethics Advisory Committee. The woman whose cases Warren had studied in law school, whose rulings had shaped the field he practiced in for the past 15 years. She had been on the Amtrak quiet car reading a novel 3 rows ahead of me. Warren's hand was on the table. I watched his knuckles go white. "Who is that?" Carson said quietly to Warren. Warren did not answer. Warren was staring at Ruth Harrington with the expression of a man watching something very large fall toward him and understanding that he cannot move. Ruth sat down beside me, placed her hands flat on the table, and looked at Warren with the patient, precise attention of someone who has heard every legal argument twice, and been impressed by very few of them. "Please continue with your motion, counselor," she said pleasantly. "We're listening." Warren made the motion. His voice held, but the rhythm was gone, the theatrical confidence replaced by something mechanical and hollow. He cited the fruit of the poisonous tree. He mentioned the State Bar complaint. He placed the check back on the table. When he finished, Ruth simply looked at me. I stood up. "The motion fails on 3 independent grounds," I said. "First, 4 of the 6 patent records I'm submitting are public USPTO filings, federal government documents available to any member of the public. There is no privacy claim of any kind against a public database. Any motion to suppress them is frivolous on its face." I placed the first exhibit on the table and slid copies across. "Second, the email correspondence and digital records from our shared home network fall within the marital property doctrine and are not protected against disclosure between spouses under either state law or federal communications statute, as established by controlling circuit precedent." Second exhibit. "But the third ground is the one that matters most." I paused. Carson was looking at me now. Patent number 11,847,302, filed by my husband's company 14 months ago, contains a specific technical method, a non-obvious optimization algorithm, that I personally developed. I have timestamped drafts, email correspondence, and handwritten notes predating his filing by 11 months. None of this information appeared in any public record before his filing date. He had access to it exclusively because I trusted him with it. I set the final exhibit on the table. This is not a marital asset dispute, this is federal patent fraud, a crime committed against the United States Patent and Trademark Office. The room was absolutely still. The mediator read the exhibit. Read it again. That is a lie, Carson said. His voice had lost its footing. Warren put a hand on Carson's arm. Carson shook it off. I developed everything in that company, Carson said, louder now. Every single idea. She explained paperwork to me. If she wanted credit, she should have put her name on something instead of spending 7 years acting like my personal support staff. That algorithm was in my head before. He stopped. The mediator looked up slowly. Carson stared back at him. He had just told this room on the record, with Ruth Harrington sitting 4 feet away, that he had heard the algorithm from me before he filed it as his own. You heard it from her, the mediator said. Carson's mouth opened. No words came out. Before we proceed, Ruth said, her voice carrying the absolute evenness of someone watching things land exactly where she expected them to, I'd like to submit a video recording of the respondent from approximately 8:47 this morning, in which he describes his current liquid assets while standing in a Tesla dealership. She slid her phone to the mediator. For comparison with the financial affidavit filed 2 days prior claiming minimal holdings. The mediator watched the video. He set the phone down. He looked at Carson. Carson's sister Renee appeared in the doorway at some point, screaming about family money and my bar license and people she knew. The mediator had her removed. Warren stood up, closed his briefcase with the careful clicks of a man who has already decided he is no longer part of what's happening, and said quietly, without looking at Carson, "You're on your own," before walking out. What came after was swift and, in the way of things that have been building for a long time, inevitable. The mediator froze all of Carson's domestic accounts and business assets pending a full financial accounting. He voided the proposed settlement as fraudulent and predatory. He awarded me 100% of the marital estate. He referred the patent fraud matter to the U.S. Attorney's Office for the Eastern District of New York and scheduled a formal evidentiary hearing. I stayed in my seat until every document was signed and entered into the record. Then I picked up my evidence binder and walked out. Carson was in the hallway, phone pressed to his ear, trying to reach someone who wasn't picking up. He lowered the phone when he saw me. He had the expression I had imagined privately, somewhere over New Jersey on that train. The one that arrives when a person who has spent years being absolutely certain of their own importance is forced, all at once, to understand that the certainty was wrong. He started to say something. Then he stopped. There was nothing left to say. He had already said the only thing that mattered, in the only room where it counted, and it was on the record now. I walked past him to the elevator. Ruth was already there, pressing the lobby button. You did that very well, she said as the doors closed. I had good preparation, I said. She reached into her blazer and handed me an envelope. Inside was an offer letter. The letterhead of one of the 5 most respected intellectual property boutiques in the country, with an office 2 miles from where we were standing, a senior partner position, a compensation package that made me read the salary line twice. Ruth had sent them my case history and a summary of that morning's work while we were still in the mediation room. They had authorized the offer before we reached the elevator. They work on cases worth fighting, Ruth said simply. So do you. I resigned from my firm by email from the car before anyone could call me first. The U.S. Attorney's Office moved quickly once the referral came through. Carson's company underwent an emergency financial audit. 2 of his 4 major licensing contracts were suspended pending fraud review. The board voted to remove him as CEO within a week, for cause meaning no severance, no unvested equity, nothing. His 40% stake in the company, accumulated during the marriage and subject to the asset freeze, was transferred to me as part of the marital settlement. The woman who had been wearing my grandmother's locket, met me outside the mediator's office on the day the final paperwork was signed. She didn't make eye contact. She unfastened the chain from her own neck and placed the locket in my hand without a word. I thanked her, which I think surprised her. I meant it. That locket had gotten my grandmother through the death of her first husband, a cross-country move with 3 children and $40, a cancer diagnosis she wasn't supposed to survive, and 30 more years of life after all of that. She had passed it to me with the expectation that I would use it the same way, not as decoration, but as evidence. Proof of what the women in our family do when things fall apart. I put it on outside the building and took the metro to my new office. 8 months later, I have a corner office on the 7th floor with a view of the National Mall. On my desk I keep 2 photographs, one of my grandmother, one of the signed partnership agreement. Some mornings I wear the locket. Other mornings I keep it in my top drawer where I can open it and look at it when I need to. Ruth Harrington has become something I can only describe as a deeply unlikely mentor. She stops by my office when she's in DC for committee meetings. She always brings good coffee and never misses a logical gap. 2 weeks ago, she forwarded me a document from the U.S. Attorney's Office. Carson had been found guilty on 4 counts of federal patent fraud. The judge sentenced him to 7 years in a federal facility and ordered full restitution to the original patent holders. The licensing revenue from the 4 disputed patents is being returned to my former clients, the people whose innovations were never Carson's to profit from in the first place. I read the document once, folded it, and put it in the bottom drawer of my desk. Then I opened the case file for my newest senior partner assignment and went to work. The thing about being underestimated for a long time is that you can let it hollow you out, or you can let it make you precise. Carson spent 7 years watching me work and concluded that what I did was paperwork. He thought the knowledge was the product. He was wrong. The knowledge is just the tool. The thing that makes the tool dangerous is the person holding it. He never thought I'd use it on him. He miscalculated, and every number in his life now reflects exactly that.